Well, honorable judges and attorneys, deans, colleagues, students, friends of LSU and of the civil law, ladies and gentlemen. I am Olivier Moreto. I'm a professor of law at this great law school, and I preside over this event in my capacity as director of the Center of Civil Law Studies. Every edition of our annual Tucker Lecture is a very special event. The lecture series was inaugurated in 1972 with Panagiotis Zepos, followed the next year by René David. Though I love reading the list, I'm not going to give you that tonight because we have now 43 names, and this is big names. We have here a pantheon of esteemed comparativist civil law scholars and an elite club, because many are alive and some are with us today, an elite club of distinguished local and worldwide jurists. I salute Professor Michele Graziadei, who was a Tucker lecturer not long ago, Vernon Palmer, and well, they joined me in the club because I was invited, and I thank my great benefactor, John Costonis. He is certainly, he's the reason why I'm here, just to make a long story short. The Tucker Lecture Series is given in recognition of Colonel Tucker's civil law scholarship and in appreciation of his long career dedicated to the promotion and the reform of the civil law in our state. Like many Louisiana civil law scholars, Colonel Tucker was not born in Louisiana, came from way north, Arkansas. He started studying law at our school in 1910. He was only 19, but at the time, you could move to law school after high school, right? The school was only 4 years old when he started, and the faculty counted 4 professors. Tucker converted to civil law. It's really a conversion for some people, and became an outstanding scholar. I will mention 4 articles that he published in the Tulane Law Review under the title of Source Books of Louisiana Law between 1932 and 35. The legislature of our state required them to be published in the volume of the Louisiana Legal Archives featuring the draft Civil Code of 1825. They remain precious material on the history of our civil law. We also owe Colonel Tucker the compiled edition of the Louisiana Civil Code that our library made available online on Digital Commons. Colonel Tucker is the founding father of the Louisiana State Law Institute, created by the legislature in view of the preservation and expansion of the civil law tradition in Louisiana. The Law Institute is a partner of our conference, and I salute its present director, Judge Holbridge. Colonel Tucker served as his first chairman and president. He initiated the master plan for the revision of the Civil Code. He promoted the translation from French into English of the civil law treaties by Planiol and other monuments of French civilian literature. John Tucker was a keen reader. He taught himself French to have a broad access to civil law literature. His interest went beyond the law. He loved philosophy, European history. On his death in 1984, he donated his rich library to our law school, over 12,000 volumes, many of which you can see in the Tucker Room in our building. His generosity also funds this prestigious lecture series. This year, we also benefit from the sponsorship of the Supreme Court of Louisiana Historical Society, represented by its chair, Phelps Gay. So 2025 marks multiple anniversary. Our Center of Civil Law Studies is turning 60 years old. And believe it or not, I'm serving my 20th year as its director, a third of its existence. I would never have believed that. It has been... Thank you. Thank you. It feels good because it's been at times a center of one person. There have been ups and downs in the history of the center, but we have here many people who have been on the team, and all our projects would not have been possible without this team. We now have an associate director, and here I salute Professor Nikolaos Stavrados. I've been blessed with amazing coordinators, such as Jennifer Lane, now Levasseur, Christabel Lefebvre, who is not with us, and presently Katie Meek, with whom we have done 2 years of work in less than 11 months. Without Katie, I don't know I would have been able to organize this event. Thank you. I salute also Aurore Gizon, who is sitting there all the back, our devoted research associate. She's also an incredible help. So the center commemorated the bicentennial of the Louisiana Digest of 1808, and the late Jacques van der Linden, a world authority on codification, gave the Tucker Lecture that year. We needed another master of the civil code for the present bicentennial, as this is the keynote event of our conference. I had no hesitation in making the choice with my brain and my heart, singing the beautiful name of Agustin Parise. Like my name, his name is a 3 plus 3. Our names combined are material for poetry. We unite in an Alexandrine. 6 plus 6. We also are 20 plus 20. Agustin enrolled in our LLM in 2005 when I started my tenure at LSU. I quickly noted his deep knowledge of the law and his ability and eagerness to develop historical and comparative perspectives. He was already an accomplished jurist when he came here. He knew more than I did on the Louisiana civil law, and to this day, I never managed to catch up with him. I needed his help. I hired him as a research associate for the CCLS. For another 4 years, we laid the groundwork for the Center of Civil Law Studies renewal. He was so diligent and delivered so fast that I sometimes called him Speedy Gonzales. Together, we founded the Journal of Civil Law Studies, now preparing its 17th annual volume. We created the Digest Online project, featuring the French and English translation of the Digest of 1808 with a manuscript note of the De la Verne volume, accessible in high-definition images and also print version. We laid the foundation of civil law online, including the Louisiana Civil Code Online, researchable on the CCLS page in English, in French, and now for a large part in Spanish. I salute the Professors Alterini who are on the validation committee, but first and foremost, Mariano Vitetta and Natalia Rezzonico, who are doing a wonderful and amazing translation. Agustin assisted me with the LLM program, running the research part of it, the research workshop. He helped me run a civil law workshop series, which, with Nikolaos Stavrados, we are now going to resurrect. It's going to come back. We co-authored Recodification in Louisiana and Latin America. That made us brother in ink, as our dear friend Paul Bayer used to say. Um, we worked on a Liber Amicorum for Saul Litvinov and a book honoring Robert Pascal. Did we do this in 4 years? Sometimes wonder. Agustin, he did all the work. Agustin and I are more than friends. We are like family. With his then fiancée, Julieta, with so much regret that she cannot be with us. She also earned our LLM 1 year after Agustin. We are thinking also of your two beautiful children, Valentine and Victoria. They had to stay home because Dutch schools do not tolerate an absence of more than 1 day, right? And it takes a little bit more than 1 day to come from Europe and to here in Louisiana. Agustin had to move on as our budget went down to 0 in 2010. He earned fellowships to conduct research at the Max Planck Institute for European Legal History in Frankfurt, and went then to the Max Planck for foreign and international law in Hamburg. In a record time, he earned 2 PhDs in law from the University of Buenos Aires, his alma mater, that was in 2010, and the University of Maastricht, the Netherlands, 5 years later, where he is a tenured associate professor. I didn't mention that, but Agustin is from Argentina. And like Pope Francis, Piedmont is Italian, though with a German grandmother. That links you to another pope. He is now a Flying Dutchman, while he remains more Louisianian than many of us. Agustin is a world citizen and a worldwide scholar. Associate professor at the University of Maastricht, which is one of the rare law schools with a true comparative curriculum. Agustin he serves as the Secretary General of the International Association of Legal Science, a branch of UNESCO. He is the Secretary General of the World Society of Mixed Jurisdictions Jurists. He is highly educated, BA in History and Bachelor's in Law from the University of Buenos Aires, an LLM in Comparative Law from LSU, the 2 doctorates that I have mentioned. Over the years, he has been a visiting scholar or researcher at countless prestigious institutions in Berlin, Bologna, Lyon, Montreal, New York, Ognati, Oxford, Paris, Sydney, and I miss certainly a few, and of course, Baton Rouge. Our LSU students had the privilege of attending his outstanding classes, both on our Baton Rouge campus and in our summer program in Lyon. He has taught at many prestigious universities on several continents. I counted 17 awards on his resume, many more than your humble servant. You are making us jealous, Agustin. If I listed his membership and the list of his publication, he would only have 30 seconds left to give his Tucker lecture. If I managed to keep him for a few more days, probably you would exceed the 200 publications by the time you would go back to the Netherlands. A few have published as much on the codes of Argentina and Louisiana and their legal history. His name pops up everywhere, and many appreciate his generosity and the quality of his work. Agustin, my dear friend, you honor us by accepting the invitation. Your name will be engraved next to Julio Cueto Rua, Genario Orcario, and Horacio Spector as the 4th Argentinian to give a Tucker lecture. You now, Argentina equals the French in number. Well, our nations are world champions in soccer and Tucker. Thank you for being with us. LSU Law, the CCLS, and Baton Rouge are your home. You're one of us. Ladies and gentlemen, please join me in welcoming our 44th Tucker lecturer, Professor Agustin Parise.
home is where the heart is, used to repeat my German grandmother Lotte while living in Argentina. This is the emotional part, then I move on. My heart is in several places as a result of my academic pilgrimage. Louisiana occupies an enormous place in my heart due to a number of people. Olivier and Marie Antoinette are foster parents in Louisiana and make everything possible. We are family since 2005. The late Paul Bayer, Louis de Laverne, Saul Litvinov, and Robert Pascal unveiled a universe of knowledge. Georgia Chadwick, Alain Levasseur, and Vernon Palmer helped keep the bridge strong. The LSU Law Center is my alma mater, and a conduit or a path for my research and teaching on the law of this beautiful state, and the weather and that lake are proof of that. Julieta, Valentin, and Victoria always, absolutely always understand and encourage my love for Louisiana. I am indebted to all who I just mentioned, and it is to them that I dedicate this 44th Tucker Lecture in Civil Law. Now, yes. The Tucker Lecture series gained reputation as a traditional forum for civil law discussion. Here you see Colonel John Tucker on the screen, with many of the doctrinal writings that we will speak about today. The civil law passion of Tucker, like Olivier mentioned, motivated a group of patrons to establish in 1971 a lectureship in his honor. The Tucker Lecture series is embedded in the activities of the Center of Civil Law Studies at LSU. As Olivier mentioned, the CCLS is celebrating its Diamond Jubilee, offering a special occasion to reflect on the life of this research and teaching habitat. In a habitat, things grow. Robert Pascal claimed in his Tucker Lecture that Miss Louisiana Civil Code was his mistress. I will not go so far, but I will claim that I have a platonic love with Miss Louisiana Civil Code. I first learned about her while I was doing research in Argentina in 1999, while analyzing the sources of the Argentinian Civil Code. I came to study at LSU Law in 2005, and ever since have engaged in research on her life. My platonic love took me to explore her past, her present, and to look into her future, always wishing her well. I plan to revisit my writings and to place them vis-à-vis my current views on the place of the code in Louisiana. I will explore to what extent we can speak of the presence of an exegetical school of private law, and I will explain what that means. Athanasios Yiannopoulos stated that, and I quote, "The study of the civil law is an international undertaking leading to the bonding of civilians," end quote. Therefore, since I'm a civilian, please allow me to share my views. This lecture is divided into 5 parts, and I promise it will last not more than 45 minutes. First, I will address codification and the Louisiana Code. Second, I will offer a conceptualization of exegesis. Third, I will offer a periodization to analyze the degree of exegesis in Louisiana. Fourth, I will speak about the dissemination of the Louisiana Code in the doctrine beyond this state. Finally, I will engage in an exercise on the future of doctrine, sharing action points for self-cultivation. Today, I will focus on the learned law, that is to say, the law as developed at universities down the road. In line with Colonel Tucker, I endorse that, and I quote, "Civil law is essentially university law. It has been developed and expanded by the teachings at the faculties," end quote. That learned law then percolates into the bench and the bar, and therefore benefits all members of society. Let us move to the first part of this lecture. Let us speak about codification and the Louisiana Code. Codification aimed to shape the way in which the law was presented, studied, and applied. It pursued the utopian goal of organizing all areas of law in a systematic, clear, and comprehensive way. This global movement started in the 19th century. There was a contagion of codification efforts on both sides of the Atlantic, and Louisiana, as I guess you suspect, was no exception. Codification can be deemed a legal paradigm, an overarching set of legal concepts that combines with ideologies in a certain society. Codification can be divided into 4 stages. First, foundation, where a seminal code sparks codification, triggering that contagion of codes. Second, expansion, where the enactment of the codes accelerates and shares traits and build on the existing models. The Louisiana Code that gathers us today is set in that second stage. Third, differentiation, where codifiers look at their own court judgments and doctrine as means of differentiate from others. And fourth, globalization, where codifiers change and start to seek to harmonize their internal private laws with that of other jurisdictions. Codification reached all continents, and as Julio Rivera stated, the 19th century was a codification century of civil law, a time when private law revolved around the codes. Ideas circulated across the Atlantic Ocean, and the paradigm of codification soon arrived to this beautiful state. The path towards the adoption of the Louisiana Code can be traced back as early as the 19th century. For example, in June 1806, James Brown and Louis Moreau-Lillet were appointed to draft a civil code. Later, in March 1808, the legislature promulgated the Digest of 1808, of which Olivier already spoke. That body of the civil law did not completely repeal the laws that had existed in Louisiana. The uncertainty about the preservation of the Spanish, French, or Roman laws led the legislature to appoint Pierre de Vigny, Edward Livingstone, and Moreau-Lillet to work on a revision. The revision resulted in the adoption of a code on the 12th of April, 1824, when the legislature ordered the printing and promulgation of the revised text. The new text had 3,522 articles, and the structure was similar to that of other 19th century codes. The printing of the code was delayed, and I don't know why. Maybe budget cuts, who knows? D'Herbigny, at that time Secretary of State, issued a certificate of promulgation for the code on May 20, 1825, indicating that the code would take effect 1 month later. That is the code that gathers us today. Let us move to the second part of this lecture. Let us conceptualize the word exegesis. Learned law in the civil world is encapsulated in the doctrinal writings of legal scholars, and Louisiana civil law, again, is no exception. Doctrinal writings shape legal science and offer a nurturing environment for codification. Treatises, monographs, translations, law review articles, casebooks, just to mention a few doctrinal writings, all of them play a role in the codification paradigm. There is a dynamic tandem, they go together, in the evolution between doctrinal writings and codification. In the words of Pascal, and I quote, "Exegesis is the art of allowing a document to speak for itself," end quote. And I shall add, through the writing of legal scholars. Most people in this room will associate the word exegesis with the work of legal scholars in France, soon after the adoption of the Code Napoleon. Members of the French Exegetical school interpreted provisions by closely following their language and by drawing on prior works, such as those of Potier and Dumas. An extreme exegetical approach limited the creativity of scholars and judges, however. Time proved that the utopian goal of codification could not be met. A moderate approach therefore emerged. As mentioned by Olivier in his Tucker lecture, codes are not straitjackets, but safeguards. The exegetical approach was replaced by an interpretation that responded more to social reality. Today, I will refer to exegesis in a broad sense, and I will not limit it to the French example. Exegesis, today in this talk, includes doctrinal writings by legal scholars that help explain and interpret the Louisiana Code. Let us move to the third part of this lecture, by far the longest. So if you thought that it was going to finish in 10 minutes, this is the main dish. This is going to take forever. Let us look at a periodization of exegesis in Louisiana. Periodization is a tool that legal historians and other historians have at hand when aiming to analyze and explain events. I will refer today to 4 periods that help analyze the degree of exegesis in Louisiana across 200 years. My periodization is an artificial creation, an analytical tool that enables the visualization of developmental stages. So it's a tool that I created to share with you. The periods of Roman law are not too remote to those that have some foundational knowledge on the civil law. And these are archaic, pre-classical, classical, and post-classical. I will replicate those familiar names in my periodization with a very, very important caveat. And that is that, differently from Roman law, the post-classical period in Louisiana will not be a point of decline. It should be a moment, a period to build on the shoulders of the prior giants, build new giants, and lead and continue leading in the field of civil law. Let us start with the archaic period of exegesis. This period starts with the enactment of the Louisiana Code and stretches until 1910. The text of 1825 experienced a significant revision during this 85-year period, however. I refer to the 1870 revision of the Code by John Ray. That revision did not trigger notable exegetical works and therefore still falls within the archaic period. The Louisiana Code did not trigger immediate exegetical reactions. This could be explained by the code itself, something that Ron Scalise told us today in the morning and that Olivier also wrote about when he explained that the Louisiana Code has a doctrinal dimension that encapsulates more definitions than the French Code. The Louisiana text reacted to a heterogeneous society, requiring the civil law to be accessible to part of the bench and bar that were trained in the common law, and that they needed to be explained some basic civil law elements. The lack of exegetical reactions can also be explained due to the accessibility to languages beyond English. Louisianians were acquainted with French and Spanish, as explained by Raphael Rabelais in an early study. A third reason relates to legal education and can help explain the lack of early exegetical reactions. During most of the period, Louisiana only had lawyers and judges, since formal law schools emerged later. For example, Gustavus Schmidt started to teach civil law in 1844 at the Louisiana Law School, the predecessor of what is today Tulane. LSU was established in 1906, Loyola in 1914, and Southern University in 1947. Indeed, Louisiana had to wait to have law schools. Tucker explained that at that time, I quote, "It is not surprising that Louisiana did not develop a wealth of doctrine," end quote. There were doctrinal writings, yet they dealt mainly with the code in isolation from other systems. Editions of the code were published. For example, in 1838, Wheelock Upton and Needler Jennings published an edition of the code with glosses, with annotations that refer to legislation, doctrine, and court rulings. There was room for translations. François Xavier Martin translated Potier, Moreau Lillet and Carleton, Las Partidas. There was also room for comparative legislation. For example, Judah Benjamin, once in England, worked on the law on sales, and Gustavo Schmidt wrote on the laws of Spain and Mexico. The book, by the way, is at the back of the room. You can see it later. Louis Ayma produced in 1840 the only work that subscribed to the extreme French exegetical approach. His Studies on the Civil Code of Louisiana commented articles and included references to French and Spanish law, to Louisiana reporters, and to writings by Blackstone, Devencourt, and Story. In words of Ayma, and I quote, "I have neither the pretension of teaching nor the design of imposing a work. I wish to be useful to the community which I have adopted." End quote. That usefulness is what doctrinal writings offer. They help explain and interpret the Louisiana Code. The pre-classical period stretches for 55 years. It extends from the failure in the adoption of the 1910 revision until 1965. In July 1908, Governor Jared Sanders appointed Robert Billings, William Potts, and William Hart to prepare a revision of the code. The commissioners presented the work in 1910. The Bar Association originally favored the revision, but after a report by a committee, decided not to recommend the proposals, which were never adopted. That failed experience is a learning tool. It is a landmark in the analysis of exegesis in Louisiana. The Louisiana Code triggered exegetical reactions during the pre-classical period. One of the reasons behind those reactions can be found in a scholarly discussion known here in Louisiana as the Great Debate, in which exogenous and endogenous perceptions of the civilian nature of Louisiana took the stage. In 1935, LSU law appointed Gordon Ireland. Ireland soon claimed that Louisiana had become a common law state. He understood that the revision of 1870 was a compilation that applied whenever there was a lacuna. Paul Ebert, Harriet Daggett, Joseph Dino, and Harry McMahon challenged Ireland's position. This scholarly discussion generated an up movement that tried to enhance the civil law. Another reason behind those exegetical reactions can be found in the establishment of the Louisiana State Law Institute. The first meeting of the Law Institute took place in 1939, a few meters from here at the Law Building, with Tucker as president. The Law Institute would then create a civil law section in 1960, aiming to revise the code. A third reason can be found in changes that took place at faculties in Louisiana. Faculties strengthened their civilian curricula. Foreign law professors trained in the civil law were appointed. For example, in 1950, the LSU Law Bulletin meant for students read, and I quote, "Louisiana lawyers must be familiar with the civil law background of the Louisiana legal system. The school therefore devotes a large portion of its curriculum to the principles, doctrine, and jurisprudence of the civil law." End quote. Doctrinal writings were produced during the pre-classical period. Importation of civilian ideas from other jurisdictions was starting to be sensed. Tucker stated that in that period, I quote, "the function of doctrine in civil law interpretation and development was being very well, but not fully performed." End quote. Editions of the code continued appearing, mainly incorporating amendments. A place of preeminence was gained by West's annotated civil code of 1952 in 15 volumes, and Dino led that effort. That text made, and I quote, "possible to trace the legislative history of each article, while annotations included the text of all appropriate law review articles." End quote. Two further publications relate to the letter of the code. On the one hand, the revised statutes of 1950. Being the first general revision of the statutes since 1870, the magnitude of the task was monumental. On the other hand, something already mentioned by Olivier, and that you saw near the hand of Tucker in the portrait, the Louisiana Legal Archives. In 3 volumes, published between 1936 and 1940, it made accessible the background text of each article. It is now available online by the Center of Civil Law Studies. There were fragmentary doctrinal writings embedded in monographs and in law review articles. The monographic work by Saunders entitled Lectures on the Civil Code of Louisiana merits special praising, being a reproduction, something that has been done during centuries, of his classes, in this case, at Tulane. The Southern Law Quarterly, for example, offered a forum for heritage and to explore development. Tucker stressed the importance of law reviews in 1938, and he stated that there was, I quote, no body of Louisiana doctrine except for law review articles of rather recent appearance, end quote. The translation of French text was a manifestation of the importation of civilian ideas. Translations were undertaken by the Law Institute in the period 1959 to 1972 and served as a catalyst during the pre-classical period for the revival of the civil law in Louisiana. Translations were directed by, among others, Carlos Lazarus and Yaro Maida, and included translations of works of Aubry and Rowe and Genie. Those translations turned to be useful tools for judges when understanding and interpreting the civil law. Tucker communicated to the Bar Association in 1935 that, and I quote, "We have had many private editions of the Civil Code, yet no complete commentary on the Civil Code of Louisiana has ever been written," end quote. That statement, that magical statement, set the tone for the classical period that followed. The classical period of exegesis stretches for 45 years. It extends from the establishment of the CCLS in 1965 until 2010. There was a renaissance of civil law in the 1960s. An Institute of Civil Law Studies was chartered in 1965. The name was changed in 1976 to CCLS. Dano from Canada was the first director. His term brought to light, among other academic results, the first volumes of the treatises series and a number of translations of French doctrine. Saul Litvinov from Argentina followed after 1975. The publication of volumes of the treatises continued, together with monographs mainly on Louisiana law. The third and current director since 2005 is Olivier, and during his term, not only the Journal of Civil Law Studies was launched and the translations of the codes, but also all the other things that we did, that you mentioned that were done only in 4 years, and many that followed after those 4 years, of course. The Louisiana Code triggered clear exegetical reactions during the classical period. One of the reasons behind those exegetical reactions can be found in the revision of the Louisiana Code by the Law Institute. A segmented or partial revision of the existing text is taking place, being revised on a title-by-title basis. Dozens of reporters and hundreds of attorneys, judges, and professors participate and have participated of the revision efforts. The sources of the revision are diverse. For example, in the area of obligations, Litvinov indicated that they studied the codes of several countries, including Argentina, Ethiopia, and France. Please note, for the record, that the revision is also built naturally, strongly on local court decisions, acts, and of course, doctrinal writings. Another reason behind the exegetical reactions can be found in the civil law treatise series started also in 1965. Similar to other treatises in the civil law world, the ones of Louisiana, I quote, analyze the historical background of provisions and institutions, collect Louisiana jurisprudence, and evaluate it critically, and compare the Louisiana Code with the codes of other selected civil law countries, end quote. The treatise series overshadowed most of the other doctrinal writings of its time. The volumes in the series were deemed systematic, comprehensive, and authoritative by Justice Joe Sanders of the Louisiana Supreme Court. By the end of the classical period, the treatise series comprised 23 volumes. A number of volumes dealt with topics closely pertaining to the civil code, such as those drafted by William Crawford, Litvinov, Frank Marais, Glenn Morris and Wendell Holmes, Catherine Shaw Spade and Richard Moreno, Catherine Veteratos Lorio, and Yiannopoulos. References to the different volumes are abundant by scholars and courts within and beyond the state, serving as a testament of exegesis in the classical period, helping to explain and interpret the Louisiana Code. Doctrinal writings were produced during this period, with Louisiana civil law obtaining a status of self-sufficiency. Isolation and importation no longer prevailed, and self-sufficiency took the stage. That is to say, local scholars had explored their own civil law, gained awareness of weaknesses and merits, and they now knew who they were and where they were. Doctrinal writings continued benefiting from code editions. For example, the West edition of the Code was edited by Yiannopoulos and now continued by Ronald Scalise. Monographs also took the stage, for example, with the writings of Catherine Spade in the field of family law. Louisiana journals welcomed civilian scholarship, with student commentaries proliferating. Translation efforts take us back to the CCLS. For example, since 1972, the CCLS made available French works in English, starting with a translation by Michael Kindred of a seminal work by René David. David Gruning, Bahir Mabry, and Roger Ward completed another set of translations led by Alain Levasseur. The classical period was enriching. Kate Wallace noted in 1976 that judges had started to refer, and I quote, freely and frequently in their decisions, end quote, to the doctrinal writings created in the classical period. I will take some water. The post-classical period of exegesis stretches so far for 15 years. It extends from the death of Professor Saul Litvinov in 2010 until the present. Let me repeat that in Louisiana, differently from Roman law, the post-classical period is not a point of decline. It should be seen as a period to build on the shoulders and on the work that has been done, that is being done, and that will be done, and that will help Louisiana lead in the field of civil law. It should be considered a period of exportation of civilian ideas, where change is welcomed, building on experience and innovating for the future. The death of Litvinov ignites this period. Julio Romaniach, a longtime contributor and friend of Saul, invited me to join him in writing an obituary. There we stated, and I quote, on January 5th, 2010, in his adoptive city of Baton Rouge, Louisiana, the great Argentine jurist Saul Litvinov bid farewell to his family, students, and disciples, end quote. Don Saul was born in Buenos Aires on March 15, 1925, this week, 100 years ago. Saul studied at University of Buenos Aires and at Yale University. He taught at LSU from 1965, again 1965, quite recurrent the year, to 2009. Dr. Litvinov occupied a fundamental role in the development of the Louisiana Code. He was reporter for the titles on obligation, sales, compromise, and exchange. Saul, in my view, was the best ambassador that Argentina could have had in the United States of America. The Louisiana Code triggered exegetical reactions during the post-classical period. One of the reasons behind those exegetical reactions can be found in the importance of language when studying the civil law. Gruning, Levasseur, Marcus Puder, and Olivier devote efforts to make Louisiana civil law available in other languages to other readership. Olivier stated recently, and I quote, "Recent translations of the code into French, German, and Spanish help revive the past international influence," end quote. There is a need to further develop civil law terminology in the English language, hence benefiting from the current lingua franca as an effective conduit of Louisiana doctrinal writings. The knowledge of Louisiana civilians is invaluable, and everybody should esteem the 200-year-plus tradition of English language civil law codification in Louisiana. That know-how needs to be further exported. Another reason behind those exegetical reactions can be found in the proliferation of mixed jurisdiction studies. Scholars gather around Vernon Palmer already for more than 2 decades, notably after the 2002 World Congress. That first gathering was followed by meetings in Edinburgh, Jerusalem, Montreal, and recently in Malta. Scholars look at Louisiana as a traditional mixed jurisdiction, where the preponderant system is no longer pure and the common law influence is sensed. This third legal family consists of roughly 16 jurisdictions, such as Israel, Malta, the Philippines, Puerto Rico, Quebec, Scotland, and South Africa. By the way, some of the places I just mentioned are represented today in the room. A third reason behind those exegetical reactions during the post-classical period can be found in the arrival of new scholars that help develop doctrinal writings. In recent decades, new ambassadors of exegesis in Louisiana have taken the stage. Some come naturally within the local law schools, and that's good, needed, and should be stressed and encouraged. Others arrive from distant places, crossing land and sea, and that also should be encouraged. They all together help explain and interpret the Louisiana Code. Others explore the Louisiana Code while being abroad, thanks to library holdings and new technologies. For example, like Olivier mentioned, the CCLS has developed the Civil Law Online platform, the Digest Online platform, all of that showcasing the rich Louisiana heritage. Judge James Dennis said that he hoped that the main output of the classical period would, and I quote, lead the way to a more significant role for Louisiana jurists and practitioners in civil and comparative law developments, both internationally and within our state, end quote. That, I believe, can be indeed sensed in the output of the post-classical period, which will now follow. Let me first state that egocentric behaviors are pandemic amongst academians. Please note that, thanks to God, many actors are alive and well. And they, I hope, will not be offended if I don't mention their contribution to legal science, because I'm convinced that even if I don't mention them, they will identify themselves and realize that they are contributing to this exportation and development. Doctrinal writings are being produced during this period, and legal ideas are being exported. Translations, as in previous periods, are important when aiming to explain and interpret the Louisiana Code. The CCLS translated the Louisiana Code into French and is undertaking a Spanish translation. Olivier leads the team of translators, with Mariano Viteta taking an important role in the Spanish text. Puder, from Loyola to the World, dealt with a German translation in Zolo, taking it to a good port in 2017. Translations were also ignited to make civilian terminology available in the English language. For example, Alain Levasseur, John Randall Trahan were members of the expert committee for the 2014 translation of the French Code led by Gruning. Levasseur led the works towards the realization of the Dictionary of the Civil Code, offering a toolbox to those approaching the civil law in English. Doctrinal writings on the Louisiana Code continued proliferating in law review articles. For example, there was a consolidation of the Tulane European and Civil Law Forum and a quick and strong emergence of the Journal of Civil Law Studies, and the other journals in the state also stayed strong. Exegesis continued percolating into law review articles. For example, glosses were made by Trahan dealing with the new laws on filiation and marital donations, while Sally Brown Richardson dealt with the conundrum of Louisiana property law. Casebooks, which also existed in previous periods and are very popular in the common law world, offer another forum. These works attend local needs, being useful tools to preserve the legal tradition. An example is found in the work of Sandy Barnado on the law of persons. An innovative work here is the Property Law Casebook by the late Evelyn Wilson from Southern University, Puder, and John Lovett. The authors state, and I quote, that they explain how Louisiana property law is different from or similar to property law in common law states and foreign jurisdictions, end quote. Exegesis is likewise present in the Louisiana Civil Code Precise series led by Levasseur. This series approaches in a modern and succinct manner the main pillars of the Louisiana Code, with contributions by civilians, including Nicolaus, Debrados, and Elizabeth Carter. These works, and many others that I do not mention today due to a lack of time, Mr. Ego, please leave the room, help export doctrinal writings that evolve within and around the code. Exportation takes place after reaching self-sufficiency. It must be agreed that in the post-classical period, Louisiana preserves and exports its exegetical output. Let us now move to the fourth part. Shorter, by the way. We will explore the dissemination of the Louisiana Code in the exegesis beyond the state. The approach will also follow the four periods that I used before: archaic, pre-classical, classical, and post-classical. The main source for dissemination during the archaic period was the Louisiana Code itself. Louisiana occupied a paramount position in 19th century codification projects due to its presence in the works of legislative concordances by Saint Joseph in French and by Garcia Goyena in Spanish. The first, the French work, with a comparative chart similar to an Excel sheet of today that compared different codes, including the Code of Louisiana in a place of preeminence. The privileged location in both works showcased the Louisiana text to the codifiers on both sides of the Atlantic and beyond. The main sources for dissemination during the pre-classical period dealt with the development of comparative law, mainly around the activities of the International Academy. Louisiana delegates always had and still have a strong presence in the congresses of the Academy. For example, Milton Colvin from Tulane wrote a general report for the 1932 Congress. Mitchell Franklin, Jerome Hall, and Harriet Daggett, the first female U.S. comparatist from this university, participated in 1937 in the World Congress. And Ferdinand Stone from the Tulane Institute of Comparative Law participated of the 1950 Congress in London. They were all great ambassadors. The Comparative Law Bureau of the American Bar Association found a forum in the Tulane Law Review. That was its official periodical or journal by 1931, and reports were published in that space, often including more Louisiana than foreign or comparative doctrinal writings. The main source for dissemination during the classical period related to the code revision and to the civil law treatises by the giants. The text of the Louisiana Code reached Europe, for example, when Estonia reformed its law in the 1990s. Yiannopoulos visited Estonia at that time and worked with the members of the local drafting committee. This adopted Louisianian was also appointed expert advisor for the Russian codification. The Louisiana Code further reached Asia. China reinitiated its approach to civil law codification in the 1990s, a task that was completed only in 2020. Several drafts of codes were elaborated for China with a Green Civil Code project, don't ask me why the name, no clue, extracting provisions from Book 2 of the Louisiana Code. The sources for dissemination during the post-classical period will be addressed in the next part of this lecture, since they relate to the action points that I want to share with you. Let us now move to the final part of this lecture. The future of doctrinal writings in Louisiana will be shaped by many of you in this room. Esin Oruku stated in her Tucker lecture that the human element is the most important factor. I hereby invite you to engage with me in an exercise in which we will explore action points for self-cultivation. So we get better, everybody gets better. A first action point relates to the need to generate synergy among actors. Let the Louisiana Code bring us together, within and beyond Louisiana. We need to listen to old, current, and new voices. We need to engage with sister civil law jurisdictions and to embrace dialogue with other systems. An upward spiral of doctrinal writings, kind of a tornado, but a good one, good tornado. I shouldn't have said that because last week there were a few tornadoes in the region, so I'm sorry for that. An upward spiral, a good one, can be attained by building teams, keyword teams. Isolation would be detrimental to the development, producing intellectual inbreeding, something you never want to reach, intellectual inbreeding, and thus threatening the survival of the civil law in Louisiana. Here, language, as many of you have realized, plays a paramount role. A second action point relates to the need to be curious and global actors. Legal science evolves in many ways. Academic curiosity opens paths of exploration and ignites awareness on the needs of society. It can take Louisiana civilians to different places in mind and body, exposing them to other cultures and ideas. We must be open-minded and engage with otherness. A third action point relates to the need to be active and thorough actors. Louisiana civilians should continue being active in the comparative and civil law environments. The International Academy of Comparative Law, the World Society of Mixed Jurisdiction Jurists, Juris Diversitas, just to mention a few scholarly hubs, all need Louisiana ambassadors. The Louisiana chapter of the Association Henri Capitan, for example, is active already for many decades, producing incredible work, sharing the Louisiana experience with the Francophone community. Ambassadors should be thorough and aim to excel. Library holdings and research funds will be needed to attain that thoroughness. A fourth, and there are only 5, a fourth action point relates to the need to be open and creative actors. The Louisiana Code will continue building and nurturing its own path, yet it should be resilient. Louisianians must allow themselves to be surprised by the details of the code, by the unexpected, by the daily evolution in the life of Miss Louisiana Code. I get emotional, but the late Tan Vu, a friend of mine from here, once told me, we were in Italy, that we should constantly reset our minds when we leave a church in Venice. We leave a church in Venice and we reset our minds. And why do we do that? Because when we do that, when we re-enter another church, we are surprised again. We should not take beauty or good things for granted. And remember, the civil law is beautiful, as Yiannopoulos used to say. A fifth action point relates to the need to look to the future while being grateful of heritage. The late Catherine Venturatus Lorio stated in her Tucker lecture in 2002 that, and I quote, "Our challenge while revising the Louisiana Code will be to modernize without discarding the classic ideology and methodology which is characteristic of our proud civil law heritage," end quote. Civilians need to be on top of developments, rely on new technologies, and be acquainted with the most current trends on codification. Yet, there is a need to cherish and protect the heritage of the Louisiana Code. Codes are meant for a society at a certain time. The needs of society are embedded in heritage and should be protected. Let us continue making this beautiful state a powerhouse for the civil law, benefiting from its unique heritage and current know-how. There must be no fear, being reassured of whom we are and where we are. The civilian world is open to receive tools and solutions from Louisiana. Let us move to the closing remarks. The opening of the Bicentennial celebrations in October 2024 offered Olivier an opportunity to state that, and I quote, "Professors have to produce solid and clear literature to guide the judiciary and the legal community," end quote. This Tucker lecture endorsed that statement. Today, together, we noted that Louisiana has had an exegetical school of private law for 200 years. In first place, this lecture dealt with codification and the Louisiana experience. In second place, we conceptualized exegesis. In third place, we implemented a periodization, isolation, importation, self-sufficiency, let's say it gets wrong, and exportation. In fourth place, we looked at dissemination of Louisiana doctrinal writings beyond this beautiful state. Finally, we explored action points for self-cultivation. These relate to a role as shapers of a civil law universe. Let me conclude by citing the great Litvinov. Don Saul once said that Tucker, and I quote, delved into the past, took apart the present, I'm trying to imitate him, but it's not going to work. Took apart the present and foretold the future in order to show that the best was there, end quote. Today, I tried to replicate those efforts with you, and in doing so, I learned and enjoyed enormously. Thank you very much for your attention. You want me to cry? You want me to cry? Thank you very much.
in all my years here, and we counted a few, this is the first time this happens. This was masterful. And who is going to ask the first question? The floor is open. And this is an exhausting exercise, but he still has energy. Carlos Amunategui.
Thank you. Well, thank you for this brilliant presentation. I would like to ask a question, maybe it's not such a smart question, but let's try. It's pretty clear that the Louisiana Civil Code has a universal influence. You can trace it in Japan, you can trace it in South America, Chile, of course, in different parts of Europe. Does this wonderful civilian tradition has an influence in the other 49 states of the United States?
Thank you very much for your comment. Okay, I take the stage. It's a very difficult question to answer because I am speaking only from my view. I'm going to tell you from my view. And I can also use different periods to answer. During the archive period, Louisiana did play a role, and we have proof of that. For example, when we look at the David Dudley Field project of 1865, we see references to the Louisiana Code. In the pre-classical period, we see some influence, but mainly in the surrounding states, where the Spanish and French heritage had continued. The further you went from the nucleus, the less you would perceive. When we move to the classical period, what we see is that because of some comparative scholars that I did mention, we would start to have later in the classical period some presence in some works of revision at a national level with uniform law projects. And there you see some delegates of Louisiana. And I'm only speaking of doctrine, I'm not looking into court decisions, because my work is limited to doctrine. And when we look today into what is happening as a way to export, what we see is that when they look at Louisiana, they look at it as a way to understand what's happening beyond their own state. And Louisiana appears like the strange creature, but it's a source of attention. Yeah. Thank you for raising that very challenging question. No, but I'm very honest. It's a part of the exercise.
Agustin, that's an extraordinarily comprehensive treatment of a very difficult subject, but I do have one question. Where are the students? Where do the students fit into this whole picture? The focus is very much on professors, old people, old forests, everything, whatever. What about the students? Where do they come in here? And what about the educational role as an important element of this whole process?
Thank you, John. I fully agree with you. I only mentioned them a few times because I assume that the professor doesn't work in abstract. If he's a professor, he has students. If not, he's a researcher, or he's a judge, or he's a practicing lawyer. So whenever I refer to the professor, I assume that when he writes, he's writing also to explain and help interpret to the students. And I only mentioned the students when I gave the example of the bulletin of 1950, where there was a reference to the students. I also referred to the law review articles that were starting to receive more and more notes by students. And I also mentioned when foreign professors were being appointed, that naturally also is because they are interacting with students. So I take your point. In the written version, I will highlight it because indeed, it has to be evident that the students and the professors are interacting, and I will make that more evident in the written version.
That's a wonderful previous role for really brilliant students who are deeply associated with the professors. What about all the students in the first year at LSU who take the course in legal traditions, for example? Where does that fit in this picture?
Yeah, no, go ahead.
Yeah, I may give testimony here because I teach legal traditions. And when we deal with the development of Louisiana law, for example, they say that Louisiana students come to me and say, we hear that the first time, or it was alluded to in a history class, or etc. And they say, thank you for bringing that to us and show how much it matters. Of course, a good traditions class, tradition is what you hand, and this is your topic, from the past to the future. It's handing over. But students are responsive. They are more responsive than we think to historical material. And there are ways and in the teaching of connecting the past to the present. You can go to the laws of the 12 tables in Rome and show horrible things like the father having the right of death, or life or death on the children. But you can also explain that given the resources of the time, there were no means to take care of those who couldn't live. You could also see that the law to protect the disabled was there in the 12th table. If the defendant was frail or was too old, transportation to the court was to be provided. A pillow was to be given. It's engraved in the 12th table. So there are multiple ways to make this significant. And tradition is something living. And that's what we try to do day in and day out with our students. That's what keeps me enthusiastic when coming to the classroom every time, not repeating material, etc. And this is part of this.
Thank you. I fully agree. And to react to your specific point, where is fitting? Well, it's fitting when we take the understanding that doctrinal writing has to include, it was to be comprehensive, the meta-juridical dimension that brings forward traditions, philosophy, history, because the study of law relates with the three things: the past, the present, and what the law ought to be. So the lege lata, the lege ferenda, and the past. So when I spoke about doctrinal writings, I was assuming that what you just named, of course, legal traditions, has to be also included. Maybe not in all the doctrinal writings, but as part of doctrinal writing, we'll be dealing with them. And hopefully that will percolate directly to the students and at a later stage to the bench and to the public. Thank you for raising that point.
Agustin is part of the answer. These international students we bring in the LLM program are a big part of that. They sit in classes with our US students. They come to know each other, and we try our best to have the mixed. And by the way, our program is probably the most rigorous in the country, in the sense that international students are not graded separately as another group, as happens in the big universities. They are graded and curved with our local students. And they know, and you know what, when I talk to them, I said, you want us to change that? They say, no, professor. This is the challenge we are ready for. This is what they want. And this school is a demanding school, historically. And we are now in the curriculum reform. I look at our dean, who is doing an amazing job at the moment. It's just, my goodness, this is one of the best things that happened at LSU, but we need to keep challenging our students and not go the easy way. Whenever we talk, you know, reform, there's always the temptation to go the easy way. Some of us resist and try to keep things rigorous.
You know what I like the most of John's question?
Yes.
Is that it proved that we're brothers in ink and that we walk together. That was a very good example.
Absolutely.
Thank you.
Absolutely.
Agustin, thank you very much for this excellent presentation and this survey. The question I want to ask you, you were being asked a minute ago about the impact of the Louisiana codification movement within the United States. And my question regards to, I personally believe that probably the achievements of this Louisiana of 1825 that we are celebrating this week is better known outside the United States probably than here. And you have the privilege of having been here a protagonist, a student and a protagonist of this part of history that you know. Now you are in Maastricht, in a country which has been also being a small country but very well known for its comparative studies. And actually the Dutch Civil Code in the Netherlands has been a very important standard in all types of modifications of new codification. What is your view now from Maastricht, where you are, about the impact of the Louisiana codification with the efforts that have been made here in the reforms of important areas of the Louisiana Code? Can you tell us a little bit about how do you see it from there, from your standpoint?
Thank you very much. And again, it's my view. What I see is that those that are engaged in codification efforts, and I can give you the example of Belgium that recently has recodified some areas, or we can think of what outside of Europe, we can think of Puerto Rico that has the youngest code of the Americas. There are some colleagues that have been looking into the case of Louisiana, not exclusively Louisiana, but Louisiana is presented in that discussion table. In some areas, it might have a more leading role than others, and in others, yes. But it's many times it's connected to something that I didn't mention, that is networks, academic networks. Sometimes it's one person that brings the code to the table and is discussed by the peers. In old days, it was sometimes connected with the embassies and the foreign office, that they would mail you a heavy book, and then everybody was around that book. Nowadays, it's more about maybe you go to a conference, you meet with someone, and you say, you know, in Puerto Rico, they're almost ready to finish the new code. Oh, I'm from Louisiana, or I know, or for example, the translation work. Oh, yeah, no, we have the code in Spanish, in German, in French. And that exercise brings it to the table. I am not going to claim that it's the main looking point, but there is, nowadays, there's no main looking point. And we see that especially because the models that we had before are also giving space to other documents that are being at the national and international level. So thank you, because it's a great opportunity to help contextualize it also within the current codification debate. Thank you.
A question from...
So, Agustin, thank you very much for such an excellent, brilliant lecture you gave us. So, the first time I read the title of your lecture, I was thinking about the French school, the French Exegetical School of Law. So this is something I thought about. So you probably could say something about, as you know, after the promulgation of the French civil codes, the school of jurisprudence that dominated the way of interpreting the civil codes, the French civil code, was that school. So what was, if you can say anything about that, what was the influence of the French Exegetical School in the first decades of the 1825 Louisiana Civil Code? Thank you.
Thank you very much. Oh, yeah, sorry. I tend to move around. Thank you, Setu. I mentioned it, but in passing, most probably, and then it was lost on the way. Indeed, the French Exegetical School was leading in the early 19th century and all the way until the middle of the 19th century, and then it's replaced by other movements that look beyond the black letter and try to place the code within more social dimension, and that's where Jenny comes in. This is to give a context. What was happening in Louisiana when the exegetical schools were developing in France, let's say, here there will be no equivalent. We have only one exception that I did mention, that is the work of Eyma, but it's not complete. He started to work on it, and he stopped. During many decades, I didn't even know well, not me during decades, but you go through the readings, and they are just mentioning Eyma without giving the name. So for this project, I did find his name, Louis Eyma. Finally, I found it in a document. And I try to get as much as I can, but we know very little from him. What we know is that he started to produce a work similar to what the Exegetical School is doing in France. That's the only example we have. We will then have to wait all the way to the classical period until we start to see some resemblance. Yiannopoulos mentioned in one piece that he understood that the exegetical school had also an impact in Louisiana. But he didn't explain it, and I couldn't find proof. And I'm not sure if he referred to the pure exegetical school as a French way or the idea of exegesis. So that's the only reference that I could find to what you are aiming to. So to keep it short, what I would say is that, in my view, there is no equivalent, with one exception, that it was not even complete. And that's why Tucker can later say, we have never had a complete exegetical study of the code. Thank you, Setu.
You allow me
Always.
a word? Okay. I would like here to dissipate the prejudice or the passé perspective that we put on the French École de l'Exégèse. When a new method arrives, those who promote the new method say the old one is insufficient, etc. But exegesis in French law in the 19th century was illuminating in many respects. This is not textualism, as so many people keep writing. This is the research of the intent behind the law. It combines with a historical approach. You have to read, those of you who read French, read Philippe Remy, Éloge de l'exégèse. It's an excellent text. And I tell my students to this day that 90% of the interpretation, if not 95%, is exegèse. We have beautiful decisions in Louisiana by Albert Tate, Jim Dennis, and others, applying the method to its fullest. So let's not be in a world of confusion here. And because you see, there's a lot of prejudice out there about Louisiana, that we are archaic. The French mock us because we still use old translation of Planiol, and Planiol, David was saying, you know, we're a little bit a carbon copy of the French, but of 50 years ago. This is not who we are. And exegèse is alive, and you proved it. You made the point, and thank you for putting the word front and central, because this is what's of most lawyering is in a civil law jurisdiction.
Yeah, and thank you, Olivier. An exegesis is natural. It's a continuation of curiosity. If you're curious, you do exegesis. So if a new law is passed by the Louisiana legislature next month, maybe, I don't know if it's happened, the first thing you do is you do an exegetical approach. And you look at it. And you try to explain and interpret.
The only times when we need a new method is when the law is very old. It's passé, cannot have been addressing artificial intelligence or aircrafts and all these things. Of course, new methods are needed there. But most of our laws are recent. Codes are revised and kept alive. And, well, we have to keep training our students to use exegesis and modern methods.
Yeah. It's natural. All right, that's my feeling. Any other comment or question? Because there can also be comments.
My comment is quality legal work wins cases. I learned French in law school, so I could win cases by quoting commentators that nobody else did, and a lot of times a little wrong.
Well, thank you for your comment. Indeed, that's what we do with students. We try to give them skills, resources, give them a comparative advantage, in a fair way, of course, and we try to empower them. So the more we can give them, be it through additional access to languages, sources, ideas, methods, traveling, reading, going to the library, everything adds, and eventually, like the case of the colleague here, it will pay off in some way or another. Thank you. Yes, please, Nick.
Wonderful presentation. Is there room for American legal realism in this exegesis that you're presenting to us?
Thank you. Thank you very much. Yes, The answer is why not?
It's already there, right?
Yeah, well, whatever, yeah. And again, it comes with a curiosity and the approach to the otherness. And curiosity should not only be from Louisiana, and resilience should not only be from Louisiana. From outside, they are invited. So if they want to explore the Louisiana Code through the glasses of realism or any other ism, I think it could work. But it's thank you for the point, because indeed it shows how there can be a dialogue within approaches.
A point that I would like you to make is we derive a lot from French law. And I love when you say, Nick, you talk about the pragmatism of the French as against the dogmatism of the German school. Say a few words about that.
I mean, well, thank you for putting me on the spot. So
Before you say, that's the point.
So here's a question. Here's a question. What if we were not a mixed jurisdiction with France, but we were a mixed jurisdiction with Germany? What would have happened then? I mean, is the German system, which I love, is it flexible enough compared to the French? My theory is that the French system is somewhere between the German and the English system. So I think that it was a wonderful marriage between the two systems, and I think that we do have a Louisiana realism.
Thank you, Nick.
And it's the bench and bar as well involved in that, and I'll just sit down now.
Yeah, thank you, Nick. Thank you very much for enriching the discussion. And now this exercise is an exercise of fiction, because there is not beer and Wurst all around this region. So there's more Spanish and French. There are some German enclaves, but it's generally French and Spanish. So my perception would be that if there was, because just to explain, to give a context, the German approach that is much more doctrinal and much more scientific, that maybe is the best word, makes it more difficult for the lay person to access the code. So we wouldn't have had Tennessee Williams saying, Estela, Estela, and they wouldn't have referred to the civil code of Louisiana, most probably. But what could have happened, and here we have Markus Puder from Germany. Hi, Markus. Maybe you want to say something. Yeah, what we could say is that we could have had what happened with Turkey. Turkey wanted to follow the German model. The German model was perhaps too tight. So what they did, they looked at the Swiss model that was building on the German but making it more legible.
With some French in it, too.
Exactly. And it was able to work. For some, for others not. But for some line of doctrine, they say that it worked. Maybe that would have happened in Louisiana. Maybe a system that would have been too remote or too distant would have triggered a snap. And maybe but this is an exercise of fiction because it didn't happen. But it could have happened. It could have. Thank you, Nick.
Thank you, Agustin, for this wonderful lecture that I really appreciated because it tells a lot about Louisiana, but also about yourself and your deep reflections about this very important story that Louisiana has. In a way, I could follow up on this comment because Italy was confronted with the dilemma between the French and the German. And this battle has been going on in Europe during the period of the so-called draft common frame of reference that was evoked here. And in many ways, we can say that the French solutions win over the Germans in some respects, for example, for the transfer of property, or as to what to do with tortious liability. Clearly, the French have been more creative in this respect. The Germans have other virtues. I don't want to, give to anybody the first place on the podium, but simply saying that this debate is obvious that could come up a little bit in Louisiana as well, as it did come up a little bit in Quebec as well. So it's logical to be open, as you said, and look in these other directions. But my point was really another one, that is to say, You have spoken about translations being important for Louisiana, and I appreciate the enormous amount of work that went into this over here. So I would like you to elaborate a little bit on translations and the future of, you spoke about cultivation and the future of Louisiana law. How do you see this? Will it be still very relevant to the development of or the systematization of the law, this activity in Louisiana, or it would simply help the diffusion of Louisiana law in other places? What are your feelings?
Thank you, Michele, for your very kind words, for offering an authoritative perspective from Europe. Oh, I'm so sorry. Thank you, Michele, for your very kind words and for your authoritative view from Europe, your expert view, bringing to the table also the debates that happened in the last decade with the DCFR and the efforts to bring the private law of Europe together and the challenges that were faced at that time. Also, for your invitation to speak about the future, or to try to foresee what will happen with translations. We were very lucky that tomorrow, the first panel in the morning, is plenary, so we can all hear to what's going to happen there. I will tell you my views, and my views is in line with the self-reflection points that I put forward. If we follow those self-reflection points, I think translations will continue playing an important role, and even more, because the more we are able to communicate, the more people are invited to the table, and the more legal science can evolve. It will, of course, need resources, both human and financial. And when we look at human and financial, we also have to look into new technologies. And that's something also I think it's you, Michelle, I was going to say Michele, Michelle, I was going Miguel, to make it in Spanish. Los dos Migueles. Los dos Migueles, Miguel will be speaking, Michel Sechan will be speaking about the role of new technologies in translations. So indeed, in line of my action points, I think it will play a very important role. Thank you for the opportunity to share this view. Anyone else? Yes, please.
So I was clerk of court for the Louisiana Supreme Court for a number of years, and before EU started, we had a visitor from France who came to Louisiana to figure out how Louisiana, in the civil law tradition, worked with the other 49 states plus territories. And it was forward thinking at that time, because with the EU formation, I guess less now with Brexit, but at that time, how is this going to work? And do you have any comments about how you think this will work in the future?
Thank you very much. So you're referring to the interaction of Louisiana law with the rest of the Union?
Yes. Okay. And how it's working in France and Germany and, well, the EU formation.
Yeah, thank you for bringing perhaps the most sensitive issue to the room. Because so far I was able to walk a thin line without having to touch on that. No, but it's important, it's topical, so we have to address it. We have to place, well, you see it in the news, the European feeling that existed in Europe 20 years ago is not the same now. And we see a manifestation in the Brexit, but it's not the only manifestation. And we just don't know what can happen, how far that feeling can grow. In the negative, I mean, not in the positive. What we are trying to do, at least I'm speaking from where I'm working, we're also trying to move now at a more global level. Also trying to find synergy in that dimension. Not so much focusing on the European dimension in isolation, that was what happening 20 years ago, because we could say that at that time they were trying to find a common ground. Well, that also comes to draft common frame of reference. So that idea now is being expanded beyond Europe. And that also brings to the table the US. So it's in that context where we have to see now the European idea. If anyone from Europe in the room would like to add to this, of course, feel free to do so. Or from the Americas also. I'm not discriminating anyone from here. I hope with this I was able to give you at least my perspective. The idea is that we are now, of course, cherishing Europe, but also looking beyond. Any other comment or question? Or Olivier, you will mention it?
I don't know if that means inviting the US to join the EU. we heard that Canada might float the idea. Any other question? Yes, Mariano Vitetta. I know that's your mic. We hold this one.
Thank you, Agustin, for this excellent lecture. I want to ask you a more personal question in line with this. Where would you like Louisiana law to go to? In what direction would you like Louisiana law to go? Now that you have described the era in when the law reviews articles started to be written, the translations of first from foreign languages into English, then from English into foreign languages, what do you think Louisiana law should look like in 20, 30, 50 years from now? Thank you.
Thank you very much, Mariano. Also for inviting me to do an exercise of looking to the future, because indeed, like when I was reacting to John's question, we speak about the law in the past, the law in the present, and the law in the future, lege lata and lege ferenda, what the law ought to be. So I take that stage now. And that is an exercise of prediction, because nobody knows. What I think is, in light of what I said, is that Louisiana should provide tools and solutions beyond the state. In light of what I see happening and the research that I did, and maybe also optimism, I think that Louisiana will be able to do that in the civil law world. What I would like is that it also does it within the union. Of course, for the record, I'm not claiming that the US should be a civil law jurisdiction. I am not doing that. But what I think is that there are many things from the civil law world, and that has been put forward. I will just give examples because they quickly come to my mind, by Olivier, by Alain, when you speak about some terms of art, also Michel, yes, indeed, you too, that those constructs, that elements of the civil law can benefit the common law. So I'm not naive, I'm not pretending that we should transform everyone, but there is value and it should be taken. Yes, Olivier.
I will add a short remark. What my wish, first one on the wish list here at LSU Law, I would like to see our common law colleague take ownership of Louisiana law and its civil law dimension. And I pronounce that with some gravity, because there is so much prejudice to this day. So much, it's always easy to look at what does not work, at failures, etc. There are some. The civil law is not perfect. No system is perfect. But if our common law colleagues would make the effort of discovering what the civil law is and listen to us and move away from that prejudice, that would be transformative. And I think that Louisiana could become a beacon in the rest of the United States.
Thank you, Olivier. And that relates to the points of self-cultivation. So if we apply some of those points of self-cultivation, curious, open, thorough, it can happen. Anyone else? Any points? Comments? I know you want to go to the reception. Me too, but we have time. I see Asia and Alain.
My point is really very short, and it goes back to the archaical period, so to archaic period of exegesis. You know, that's a very small point, but you may want to add this curiosity.
Yeah.
When I worked with the archives of the Quebec Codification Commission for the old code of 1866, there was a very interesting document entitled Livres à se procurer, books to be obtained. And one of the items there was commentaries on the Civil Code of Louisiana. So in 1850s, Quebec codifiers expected to be something similar to the French commentators in Louisiana, while there was none. But the expectations were high, so they had hope in Louisiana civil law scholarship, and they expected this to be the case, but they had to end up with Jenkins' edition that inspired the reports of the Quebec codifiers with the sources underneath the article. So you may want to add this to the written version of your paper. Thank you. It has been a great presentation.
Thank you, Asia. And Asia and I know ourselves for a long time. And Asia is a very generous person because she always mentions things. You gave me a few pointers. I thank you in footnotes also, in star footnotes. You already gave me some pointers with Lorimier and the library, the Bibliothèque de Code Civil of Quebec. So I'm glad it's being recorded because I didn't take note. But I will look at that. Thank you, Asia.
My point is going to be even briefer than that. As an answer to the question that was asked about the influence that Louisiana civil law can have on the common law, to take a Louisiana image, there is no captain on the paddle boat.
Sorry, Alain, I couldn't follow.
There is no captain on the paddle boat.
Okay.
Or,
oops. Okay. Thank you, Alain.
There's no one to point us in the right direction.
Yeah. Thank you, Alain. Thank you for your view. And this statement triggers self-reflection and to see what, if that would be the case, what could be done to put someone leading the boat. That's part of the exercise, to trigger awareness or to share those feelings and to do an up spiral. Thank you.
Well, I think it's time to conclude. And I will do it with just one short sentence. It will be damn hard to find the 45th Tucker lecturer. You put the bar so high. Thank you.
Thank you all very much.
And Agustin, this is a personal token of affection and friendship. It takes us to the archaic period that you mentioned.
It smells good.
Yes, yes.
It's old books. Can I open them now?
Please. Please.
First point, remove the wood. Second point, the gloves, but I don't have.
No gloves needed.
Enjoy. In Spanish.
This is Doma, Jean Doma, les lois civiles dans leur ordre naturel in Spanish.
I show my students this in a photocopy. Es Las leyes civiles en el orden natural, por Jean Doma, 1841, Barcelona. And this is getting very good, even with some notes. Código Civil de la República Argentina. Wow. It's an edition of 1889 of the Argentinian Civil Code with the daguerreotype of the drafter, Dalmacio Vélez Sergio. I'm very moved. Thank you very much. Thank you very much.
Thank you.
Thank you very much. Very special.
And without further ado, I invite you to follow our wonderful guides to the other building where we'll have the reception, refreshments, and food. Thank you very, very much.